Hello everyone, I'm Vincent Genotiva. Today I'm going to discuss about Presidential Decree number 968. Section 4, Grant of Provision. Subject to the provision of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, suspend the execution of said sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best. So what is probation? Probation is a privilege granted by the court to a person convicted of a criminal offense to remain in the community instead of actually going to prison or jail. So let's proceed to the section 5. Post-sentence investigation. No person shall be placed on a probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice in the best interest of the public as well as that of the defendant will serve thereby. So the main task about post-sentence investigation, after conviction and sentence, an offender or his counsel files a petition for probation with the trial court, which in turn orders the probation officer to conduct a post-sentence investigation to determine whether or not an offender may be placed on probation. So let's proceed to the section 6. Form of investigation report. Okay. The investigation report to be submitted by the probation officer under section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. What will happen if the application for probation is denied? The offender will be sent by sentencing court to prison to serve his sentence. Section 7, period for submission of investigation report. The probation officer shall submit to the court the investigation report on a defendant not later than 60 days from a receipt of the order of said court to conduct the investigation. The court shall resolve the petition for probation not later than 5 days after receipt of said report. Pending submission of the investigation report and the resolution of the petition, the defendant may be allowed on temporary liberty under his bail filed in the criminal case, provided that in case where no bail was filed or that the defendant is incapable of filing one, the court may allow the release of the defendant and recognize the custody of a responsible member of the community who shall guarantee his appearance whenever required by the court. So, in section 7, the probation officer must submit the post-sentence investigation report within 60 days upon a receipt, but the period may be extended in a meritorious cases for a period that will be approved by the court. Section 8. Criteria for placing an offenders on probation. In determining whether an offender may be placed on a probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Probation shall be denied if the court finds that A. The offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution, or B. There is an undue risk that during the period of the probation, the offender will commit another crime, or C. Probation will depreciate the seriousness of the offense committed. Okay, in section 9, disqualified offenders. The benefits of this decree shall not be extended to those A. sentenced to serve a maximum terms of imprisonment of more than 6 years, B. convicted of any offense against the security of the state, C. who have previously been convicted by the final judgment of an offense punished by the imprisonment of not less of not less than 1 month and 1 day and or a fine of not less than 200 pesos. D. Who have been once on provision under the provisions of this decree, and E. Who are already serving sentence at the time that substantive provision of the decree became applicable pursuant to Section 33 hereof. Section 10. Condition of provision. Every provision order issued by the court shall contain condition requiring that the provisioner shall A. Present himself to a provision officer designated to undertake his supervision at such place as may be specified in the order within 72 hours from a receipt of said order. B. Report to the provision officer at least once a month at such time and place as specified by said officer. The court may also require the provision to cooperate with a program of supervision, meet his family responsibilities, devote himself to a specific employment, and not to change said employment without the prior written approval of the provision officer, undergo medical, psychological, or psychiatric examination and treatment, and enter and remain in a specified institution when required for that purpose, pursue a prescribed secular study or vocational training, or attend or reside in a facility established for instruction, recreation, or residence of a person on provision, refrain from visiting houses of ill repute, abstain from drinking intoxication beverage to excess, permit to provision officer or an authorized social worker to visit his home in place or work, reside at premises approved by it, and not to change his residence without its prior written approval, or satisfy any other condition related to the rehabilitation of the defendant and not unduly restrictive of his liberty or incompatible with his freedom of conscience. Section 11. Effectivity of provision order. A provision order shall take effect upon its issuance, at which time the court shall inform the offender of the consequences thereof, and explain that upon his failure to comply with any of the conditions prescribed in the said order or his commission of another offense, he shall serve the penalty imposed for the offense under he was placed on provision. So, let's proceed to the section 13. Control and supervision of provisioner. First, the provisioner in his provision program shall be under the control of the court, who place him on provision subject to actual supervision and visitation by a provision officer. Okay. Second is whenever a provisioner is permitted to reside in a place under the jurisdiction of another court, control over him shall be transferred to the executive judge of the court of first instance of that place. And in such a case, a copy of provision order, the investigation report, and other pertinent records shall be furnished and said executive judge. Thereafter, the executive judge to whom jurisdictions over the provisioner is transferred shall have the power with respect to put him that was previously possessed by the court which granted the provisioner.